Okay, ladies and gentlemen, gentlemen and ladies, ladies and gents, we gonna bring y'all this episode right here of Writ of Habeas Corpus. And this habeas corpus is being done for several reasons. I would sit up here and give you guys the definition of a habeas corpus, let you know what it is, but that's not my job. So y'all just gonna have to just sit back and do your own research and understand the definition of habeas corpus. Sorry, I'm waiting for this to pull up and I didn't want to put it in twice because I almost did that. We don't need these addresses at the end just so y'all know they at the end. Hold on one second. Writ of habeas corpus. Okay, let's... Alright, now what we're gonna do, there are some things that I'm gonna take out of here because if I don't, you guys will be hearing / backspace / we don't want y'all to be hearing all of that, so we just gonna let y'all hear the simple stuff like that, so y'all ain't gotta listen to all of that / backspace because it will do it, okay, because it's a hyperlink and a hyperlink has all of those little nuances to it, and so we don't want to hyper y'all with y'all links. Oh, I want some hot links. Exactly. So let's go up and away. Alright, we can get rid of this the caption part because it's not necessary. I don't need to get rid of all of it. Oh yeah, it's going to do everything because it's a block. So let's get rid of the block. Okay. Alright, we're going to start it. I'm going to put this young man to sleep because he is too loud right now. And we're going to let... Is it Zero? Kate going to talk for us today? I had Zero talking the last time, but that one didn't work out. So, oh, we even got Russian. But we're going to keep it at English, okay? We ain't going to have nobody talking Russian, right? Not right now. Okay, we're going to let Kate talk. Let's bring Kate to number 2. Anything shorter than number 2 is horrible. By the way, this is Natural Reader, and I think this is volume number 11. They all work the same, whether you have 11, 14, or 15. 15, if you don't have the registered version, it keeps giving you all these stupid pop-ups. Now, we're going to explain this habeas corpus. Now, you guys know about the Credit River decision. Okay, in this particular document, and this is my second time doing this video. The first time it did not record my audio, so I had to do it over. An hour and 30 minutes the last video took. Hopefully this one won't take that long. We're going to let her read, and I'm going to make the corrections as she read, and I'm going to do the best I can not to really stop her, but if I have to stop her, we're going to stop her, okay? There are certain things that I will explain in advance so that you get it. Again, habeas corpus is not just simply to free the body, although the word habeas, to release or to set at liberty, corpus, body, even though that's what it implies, the Supreme Court has stated that a habeas corpus can be used when an individual is suffering from any restraint on their liberties. Okay? Because that's what habeas means, to release, to free. Okay, so it doesn't just associate itself with the body. You guys, a lot of people want to look at things literally, without looking at it literally. So because habeas means to free or release something that is held at bay or held in confinement, an individual who is on probation can do a writ of habeas corpus in order to get that contract null and void. There are a couple of things that we're going to talk about here that's going to talk as to whether or not what's being done around us is lawful. Doesn't matter if the courts rule this or rule that, as you saw with the Credit River decision and the Supreme Court. Go back and look at the original instrument. You must stick to the foundation. The original instrument being the Constitution, and the original instrument for that being the Northwest Ordinance. Okay, this was a justice of the peace judge. Pay attention to the fact that this man, born in 1915, okay, born in 1915, this man died in 1969. Anybody want to do the math to let you know that he was in his 40s at the time of his death? And that being in his 40s, that he didn't just learn law. He couldn't just be a justice of the peace because he felt like it. Okay? And the fact that he said he was relying on the Northwest Ordinance. He didn't make that up. He understood. He even put case law in the decision and opinion. Sorry, I got a threat. Is somebody making a threat on you, son? No, nobody making a threat. I had a threat. I got to get rid of that later. It's already set to the side. I already put it to the side. Now, we're going to let this play, but let's let you guys know that that judge, I would be a fool if I was to believe that he died of so-called natural causes while fishing. See, there have been reports about him drowning and other reports about him being poisoned. But the circumstances are fishy because he dies a day after Daley goes before the Supreme Court to argue whether or not they were bound by the Supreme Court order to stay any further proceedings in any of the other cases. Take a look at the 7th Amendment, people, of the United States of America Constitution. You will see that once a jury hands down a verdict in a common law matter, that verdict cannot be overturned by any court. So the Supreme Court of the state of Minnesota could not invalidate that order. Nobody's ever raised that point. That's right, you heard me say it. Nobody has ever raised that point. Oh, well, the Creditbury case was overturned. No, it wasn't. You can't overturn that. No court has the jurisdiction. Go and read the 7th Amendment again, people. No court has the jurisdiction to overturn the so-called 7th Amendment, a jury trial verdict. That is the whole purpose of the jury trial system, is that any decision made by a jury that is unanimous cannot be overturned by any court unless there is an unless. You mean there is an exception? That's right, to the rule. Unless the decision the jury came to is so erroneous that any normal, reasonable person would not have come to the same conclusion. Or, well, they say reasonable jury. Ladies and gentlemen, since Jim Crow and all of the other trials where individuals were put to death because of their color of skin, back then, those juries came to whatever verdict they came to, but in reality, no reasonable jury would have made the same conclusion. See, that jury was unreasonable because everything they did was based on race. If you had your choice of colors, so which one would you choose, my brother? Let's let Kate, if there was no day or night, speak to us.
The District Court of the United States of N for America. A judicial branch venue. Attested affidavit. Writ of habeas corpus common law right remedy.
I gotta take care of her. She's jicky.
1.
Did you just make that word up?
Habeas corpus was adopted by the United States of America under common law, and thus it is a common law remedy and not a statutory remedy. 2.
First, let me explain that. The first paragraph explains that habeas corpus was adopted. And the reason why I'm going to keep both windows open because I have to make some corrections. But the writ of habeas corpus was adopted into the United States from common law. Common law was adopted from England. Sorry, I just replaced in Windows on my computer. And so I got to get rid of Windows old. So it's deleting that junk. A lot of deletions. But let's get back to this so that you guys understand. Writ of habeas corpus is a common law remedy. It's not a statutory remedy. So you'll find that when it comes to statute, that what they did is they came up with a statute for habeas corpus. It was 28 USC 2254, 2255. The 2254 is for state-related cases that are brought to federal court. Yes, you can. If you're in a state court, you can bring it to federal under 2254. They're going to talk about exhausting administrative remedies, but the law says now that you do not have to exhaust your administrative remedies. Okay? It is no longer a requirement. It never should have been, because what you must understand, the Constitution says that there should be one Supreme Court which shall have original jurisdiction over all matters. Ladies and gentlemen, when you hear the word original jurisdiction, it's referring to common law. See, jurisdiction is not the venue. It's the authority by which they act. For the court to have jurisdiction, for the police to have jurisdiction, they must have something delegating authority to them to have jurisdiction. That's what all the case law has been saying. Well, what happens is that the police have two capacities. One is peace officers. The other are law enforcement officers. When they use the term law enforcement officer, they are referring to their statutory capacity. When they use the term peace officer, they're referring to their public servant capacity. Won't give you a lot of details about that on this video for how you should be asking questions back of them under what capacity are they present. We'll do a video on that very soon. But let's get back to habeas corpus. It predates all of the laws of the United States. Go back and look at the Habeas Corpus Act of, I believe it was 1686 or something like that. It's called the Habeas Corpus Act. Okay? It actually is called that because habeas corpus has been around a lot longer than the United States was even dreamt of being around. So let's continue, shall we?
Yeah, we should continue.
Corpus predates any statutory schemes by Congress, and according to the Northwest Ordinance, this right, which is not a privilege, is available to all and can never be suspended. 3. The Northwest Ordinance of 1787 is the foundation for the United States Constitution of America, and that instrument was founded under common law and the sovereign authority of the United States Congress. 4. And as per the general principles of lawmaking, Congress has no authority to repeal the Northwest Ordinance, the Constitution of the United States of America, the right of the people to seek redress via habeas corpus. 5. The right to petition the government, that is the sovereign, was envisioned by the framers of the Constitution and the Northwest Ordinance, for they specifically made it clear in both instruments that the right to petition for habeas corpus, that is a correction of unlawful servitude and or constraints of an individual's liberties.
Hold on. I'll explain that in a second, but I want to get rid of Kate because Kate's voice is, I think it's her voice. I don't think it's more so. We're going to do Zira because I did her the other day. So we're going to do Zira and we're going to let Zira do it 1. Okay, but let's explain this paragraph. The right to petition the government, i.e. the sovereign, was envisioned by the framers and farmers, brought together of the Constitution in the Northwest Ordinance. For they specifically made clear in both instruments that the right to petition for habeas corpus, i.e. a correction of the unlawful servitude and or constraints on an individual's liberty, by clearly stating, we'll see, the right to petition by clearly stating, let's get rid of both instruments. The right to petition for habeas corpus by clearly stating Congress could never make a law against such. The First Amendment. Congress shall make no law abridging the right of the people. Okay, well, the right to petition is yours. They can't take that away from you. Go back and look at the First Amendment. You have the right to petition, not just for redress, but to petition. Okay, that's how the law reads. See, when they say, or the right of the people to petition the government, then it says for redress or grievance, you have the right to petition government. No one can stop that. Okay, Congress shall make no law is the very first set of words, and we got to get rid of that in that paragraph. Okay, where is it? Stating Congress shall make no law. The framers, for they specifically made clear in both instruments right petition, i.e. correction. Where is that word that, y'all? Correction of wrong servitude. I don't know what I'm missing. I'm missing it, y'all. I know it's right here in front of me. Let's see, it's number 5. And that the right. Okay, so that's the point. Okay, that's the that I'm looking for. I told you it was right in front of me. Why didn't y'all point it out to me? What's wrong with y'all? God. All right, hold on. Let's let Zira let her finish talking.
By clearly stating Congress could never make a law against such. Ergo, they could never amend the right to such a guarantee.
Come on, Zira.
6. The right to petition government that is the sovereign is a secured right, a common law right that predates the Constitution and the Northwest Ordinance, and it is a right that is utilized when exercised, a right that cannot be heard in equity. 7. The right to petition for habeas corpus is not an equitable right, but a right that is fundamental to the treaties, constitutions, due process, and equal protection clauses, as well as the right to life, liberty, and the pursuit of happiness. 2. Common law jury trial demanded. 8. Writ of habeas corpus is a petition to the sovereign government asking that body to intercede on behalf of a citizen. 9. Recognizing the fact that the writ of habeas corpus is a civil proceeding, the right to a trial by jury exists even within the confines of such a proceeding under the principles outlined in the Constitution for the United States of America. 10. Acting as we do in recognizing...
Hold on. Let me explain what I just said. I just told the court, since habeas corpus is a civil proceeding and they always let you know it's a civil proceeding, since it is a civil proceeding, we add a value to it. There is no law saying that there cannot be a value associated with habeas corpus. What if the value is our estate? Okay, but as long as it has a value of greater than $20, you have the right to a jury trial. So I'm saying that because it's always been recognized, I'm going to explain why you have a right to petition a branch of government that nobody ever talks about. Pay attention. Now look, this is an argument, and it's whoever puts it together better is the one who will get it done. I'm just bringing it forth.
That common law still exists in United States of America. See Memorandum of Law section below. We know that the American government or representatives of the people as defined by the Constitution, and since the government represents the people and the wishes of the people, then one would have the right to petition the people, that is common law jury. See Memorandum of Law below. To a jury of talesmen to be called, impaneled, and sworn to try the issues in this case. 11. In the United States of America, it has been well founded that the sovereignty resides in the people. The definition for the people is the common national community, for even the word community comes from the word common, that is common law, and unity, that is government. 12. The right to petition for writ of habeas corpus never excluded the right to a jury trial, as this was an adopted common law, whereby individuals normally would petition the king. There can be no such entity in the United States of America, and because the sovereignty of the United States of America rests in the people national community, I have the absolute right to bring this civil matter before that body, as was had and done in the Credit River matter, within the borders of the great state of California, a common law state, and I am exercising my rights continuously along with any reservations and retentions necessary to effectuate my interest in obtaining justice according to its Declaration of Independence standard, the Northwest Ordinance standard, the United States of America Constitution and its organic Republican form standards, and the biblical standards. 3. The respondents.
Don't worry about
Deutsche
the
Bank
respondents.
Trust CO
Those are the
America.
actual addresses for the several banks for several
60
different
Wall
properties I'm
ST.
going after.
New York, 10005.
Sorry, y'all gotta listen to that.
B Caliber Home Loans.
Wait a
Inc.
minute. Hold on. Y'all ain't gotta listen to that.
1525 South Beltline Road.
I told you I already did this video. And so to get rid of that, let's see. We get rid of that. Uh-oh. I don't think it wants to let me get rid of it. I think I have to do this. Okay. So fine. I'll get rid of it. Don't need that anymore. Anyway. Alright. Let's continue.
4. Jurisdiction of the court. 13.
I got something
14.
I'm gonna
This
put
court
there.
has jurisdiction under the 7th Amendment of the United States of America Constitution, the
Wait,
Northwest
hold on.
Ordinance, Article 3, and the
Hold
Declaration.
on. Watch this. The original jurisdiction of the court is common law, comma, this court has original jurisdiction at common law, comma, and it is at common law that I present this, my petition for redress, period. Stop listening. Okay, I typed it up, but I needed to polish it up, so this is what I did. I said this court is under obligation to recognize that the original jurisdiction for the United States is common law, and as a result, each constitution is founded under common law, as it is mandated that every state must recognize the common law Bill of Rights, which guarantees everyone, got to change the there, but I also got to put a comma there, and we got to, where's my there? Come on, I got the little spinning circle. Got me going in circle. Sorry. All right. Which guarantees everyone their right to be secure by securing them within the framework of that document. You see, the Constitution is called a security agreement because it secures those rights which are automatically yours. You don't have to buy them. You don't have to go out and beg for them. These rights are yours without any documentation. They are called natural rights or common law rights. You don't have to do anything but assert your common law rights in their so-called administrative courts. I've never waived these rights. I do not wish to waive these rights. I don't consent to waiving my common law rights. That's all you got to do, people. Just hold on to it. Don't let go of them. They're yours. Don't insist upon them. In other words, I will die before I give up these rights, because somebody's going to pull your card, call you to the floor, that type of thing. So y'all just be patient. All right. This court, under such recognition, has original jurisdiction under common law, and it is at common law that I present this, my petition for redress. Okay? So just wanted to let y'all see what I added, because I done added some stuff. All right. Zero
of independence. 15. This court has the ability and capacity for operating and acting in a common law capacity the same as the court did in the case associated hereto and inclusive by reference in the Memorandum of Law section of this presentment. 16. The court, however, does not have the authority to deny, ignore, and or refuse a redress petition, because such an act would equate to converting a secured right into a privilege, which would make the act in and of itself, without discretion, without delegation of authority, unconstitutional. For the court was put in place for this very purpose, and cannot ignore the purpose for which it has been put into place.
Hold on. Give me 1 second. You know, I'm back. I just did a video earlier today telling people about the so-called appetite suppressant that I stumbled across. And I did the video and I said it would probably be after 6 before I eat. It is just about 6 o'clock. Where's my clock? See, 5:50. And I'm not hungry. But I haven't eaten today. So I'm going to have to go eat something, because I have to eat something today. I ate twice yesterday. Yeah, I ate twice yesterday. So today I will probably eat only once because I'm tired. So I'll probably eat and go to sleep.
Are you gonna eat, sleep, and do that other thing?
Your mama. Anyway, here comes the rest of the story. And that is Mr. Harvey. And now you have the rest of the story.
V. The right to property and not the privilege to property. 17. So envisioned by the framers of the Constitution and the Northwest Ordinance was the right to the possession of one's own property, that it has come to be known as the right, not the privilege to property. 18. A privilege is not a right is an entitlement, and the right to property, the right to life, the right to liberty, and a restraint on one's property is a restraint on one's liberty, or foundational principles, and any statute, rule, and/or regulation that speaks to the contrary is repugnant of the Constitution and the Northwest Ordinance and cannot be utilized without violating the law of nature, the law of nations, and the treaties and other contracts instituted within the borders of the United States of America, its possessions, its territories, its interests public or otherwise. 6. Challenge to unconstitutional acts/statutes/regulations/codes. 19 in 1933 on or about March 3, the President of the United States Theodore Roosevelt instituted a proclamation, number 2038, convening a special joint session of the United States Congress in General Assembly, scheduled for March 9, 1933. 20 on March 6, 1933 the President of the United States issued a second proclamation, declaring a national, meaning nationwide/all-encompassing, banking holiday, that was to take effect March 9, 1933. 21 before the President's proclamation could take effect on March 9, 1933, the United States Congress announced to all of the world and the nation that the United States was in a state of a national banking emergency, that is bankruptcy. For validation of this, please see congressional records associated with the National Emergency Act, whereby Congress admitted that the nation has been in a state of national emergency since 1933, and by that act continued this ongoing serious national emergency. 22 thereby making the proclamation of the President, 2038 through 2040, public law. 23 it was at this very point that Congress announced that it was commandeering, seizing control of all the people, their assets, and their properties. A Senate Report 93 to 549, July 24, 1973, since March 9, 1933, the United States has been in a state of declared national emergency. These hundreds of statutes delegate to the President extraordinary powers exercised by Congress, which affect the lives of American citizens in a host of all-encompassing manners. This vast range of powers taken together, confer enough authority to rule this country without reference to normal constitutional process. B. Congress's own words, we are here now in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization of any bankrupt entity in world history, the United States government. Congressional Record March 17, 1993. P.H. 1303. See, you will say that's not true, the United States is not bankrupt, the United States is not in bankruptcy. However, Congress has admitted this, and when it was stated on the congressional floor no one rebutted it. Now 25 years later, remembering that it is now part of the Federal Registry, part of the congressional record, it cannot be denied, for the rebuttal period and statute of limitations for rebuttal has been terminated. D. The federal government has stated officially that legal tender has no value in the United States during the pending bankruptcy. Since 1933, Federal Reserve notes are not redeemable, and receive no backing by anything. This has been the case since 1933. The notes have no value for themselves. An official website of the United States government, the state must provide a remedy for the current crisis. Am I to understand that this court does not recognize the obligations of government, and that all debt in the United States is construed as a government obligations? E. If the answer to the preceding question is no, that the matter did not involve a government obligations, then please explain the congressional intent with reference to the following congressional notes of the congressional record for the enactment of the March 9, 1933 Emergency Economic Banking Relief Act. F. The ownership of all property is in the state. Senate Document Number 43, 73rd Congress, First Session. G. Under the new law, the money is issued to the banks in return for government obligations. The money will be worth 100 cents on the dollar, because it is backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people of the nation. Congressional Record, March 9, 1933 on H.R. 1491 p. 83, c. 12 U.S.C. 411. H. Am I correct in understanding that the government is obligated to supply and provide a remedy to the national community, otherwise known as the people as a whole and individually? I. And if they are not to provide a remedy, does this not defeat the purpose for which they stand as representatives? 24 Constitutional Question and Administrative Procedural Challenge continued. Did the Congress have the authority to delegate its congressional powers to the President of the United States or any other branch of government? Could Congress delegate and/or confer authority to rule as sovereign, representing the legislative branch of government to the administrative or executive branch of government? 25 When Congress admitted in 1973 that they had indeed as a body, as a group, as a representative branch of government acted unconstitutionally, did such acts and/or acts invalidate the subsequent acts created as a result of the original unconstitutional acts? Keep in mind the forbidden doctrine. 7 Bankruptcy Protection Provisions in Extension. 26. As a result of the unconstitutional Emergency Economic Banking Relief Act, the United States Congress in General Assembly declared a national banking emergency, that is national banking holiday, which was serious enough to halt all banking activities. This created a haven for the people, a remedial avenue until such time as such emergency was declared no longer necessary, did it not? 27. Since the national banking holiday of March 9, 1933 is still extant, as was the congressional intent as highlighted in the National Emergencies Act, this would equate to the fact that government was to have provided a remedy for the people before the ownership of all property is in the state. Under the new law, the money is issued to the banks in return for government obligations. The money will represent a mortgage on all the homes, and of all the people of the nation. Congressional Record, March 9, 1933 on H.R. 1491 p. 83, c. 12 U.S.C. 411. 28. In the real estate market, the real estate scheme, the protections that have been put in place by the legislature are being overridden by the court's failure to recognize these prohibitions. The prohibitions instituted by the lawmakers, that is Congress, have been subjugated by equitable decisions that are not equitable. 29. For instance, in the great state of California there is a tax and revenue code. This tax and revenue code specifically highlights that the tax and revenue form 502A must be completed before the transfer of ownership rights to any property can be perfected. This has not been complied with respects the properties for which I, the petitioner, exercise power of attorney. The failure to comply with the statutory scheme implemented by Congress has resulted in a restraint on my ability to carry out my duty as attorney. In fact, this constraint or restraint on liberties is unconstitutional, and there is no remedial course in law capable of correcting. A California Tax and Revenue Code 480.3 www.search-california-law.com 30. It has already been adjudicated at common law, that the banks during this banking holiday do not lend money, they lend what is referred to as bookkeeping entry credit. Nowhere within the framework of the Constitution or within the framework of any statutory scheme does a bookkeeping entry translate to money with reference to property and loans. 31. Bookkeeping entry credit is unconstitutional and unlawful. 32. Even if defendant could be charged with waiver or estoppel as a matter of law, this is no defense to the plaintiff. The law leaves wrongdoers where it finds them. See sections 50, 51, and 52 of M. Jur. Second Actions on page 584. No action will lie to recover on a claim based upon, or in any manner depending upon, a fraudulent, illegal, or immoral transaction or contract to which plaintiff was a party. 33. Plaintiff's act of creating credit is not authorized by the Constitution and laws of the United States, is unconstitutional and void, and is not a lawful consideration in the eyes of the law to support anything or upon which any lawful right can be built. 34. If the bookkeeping entry of credit was unlawful in 1968 and was never consideration, which is always necessary in a contract, that is simple contract includes value and consideration, and a contract is void if it does not include the aforementioned, then it is unconstitutional in this instance, which means the party holding our right to property and restraints actions are unconstitutional, does not constitute a perfection of title, a perfection of claim, and is a breach of fiduciary duty. We are entitled to a judgment and declaratory form, which secures ownership of the property, directing the county recorder to clear title of any encumbrances henceforth. For until the national emergency is declared finally over, no longer extant, the Federal Reserve's recourse at law is in statute, for the statute provides an equitable remedy for the Federal Reserve and its member banks, c. 12 U.S.C. 411, as the Federal Reserve and its member banks at this as an option from the beginning, it is an option that they utilize continually. It is alleged that they have done so in this instance and failed to document the record, which means they have brought forth a constructive and fraudulent claim. And as is known under maximum law, if they have acted with dishonesty, the court cannot reward their dishonesty. 8. Denial and failure of process. 35. On or about February 3, 2018, the defendants each of them received a complaint in the form of the dispute to their claims. To the present day there has been not one single response as required by law. 36. Due process requires at a minimum that a party be notified that a matter is pending and can choose for his or herself whether to appear, to forfeit, to acquiesce, or consent. The fact that a hearing is not in a specific or particular form does not negate the root requirement that a party be notified. We have satisfied this common law root requirement. 37. Because of the failure on the part of the respondents, they are stopped from raising any claims or rebutting any of the documentation sent them previously as the statute of limitation has run its course. 9. Flagrant breach of fiduciary duty. 38. The law requires that the property have mortgage default insurance, and this despite the fact that we are in a current economic banking emergency, an emergency which has suspended all banking activities until the banking holiday is declared over by the actual repeal of the March 9, 1933 Act, which the United States Congress and General Assembly has elected not to do. This was the precise reason for the National Emergency Act, the congressional reports associated thereto, as Congress documented the fact that it was necessary to continue the March 9, 1933 Act until further notice. 39. Be that as it may, and that is not to say that we do not believe that the act aforementioned and the acts of the trustee are unconstitutional, it is to bring forth the point that the mortgage default insurance, otherwise known as mortgage insurance, being required for all government obligations associated with properties, carry with them insurance against default. Each of the aforementioned properties have such insurance associated with them. 40. The trustee has a policy, one that is not part of the original agreement, to forego applying for the insurance by filing a claim, insurance which is specifically there to protect the lender should the borrower default, keeping in mind that the trustee's main responsibility is to protect the lender and its investment. 41. By electing to forego following an insurance claim, the trustee under his assumed authority is acquiescing to the fact that there was never any loan to be insured against in the first instance. Please see the memorandum of law below for verified proof of the unconstitutional practices of the financial institution and those who act as trustees for these agencies. 42. By electing to foreclose which has already been determined to be a final act and not a first act, the trustee on behalf of the lender/beneficiary is violating the terms of the agreement, and the intent of the grantor, which is law of the trust. 43. Deed of trust is no more than a common law trust, having all the elements of a trust, the language of a trust, the characteristics of a trust. If it walks like a trust, looks like a trust, it is a trust not just in words only. 44. Because there is a trust relationship, a trust agreement, the grantor's intentions is law of the trust. 45. It is for the very fact the reason why the grantor pays the insurance on the mortgage against default, to protect not only the grantor's interest, but also the entrance of the beneficiary/lender. 46. In every instance, and every deed of trust, in every relationship with every financial institution, there is a clause that highlights mortgage insurance is there to protect the lender. And because each of these loans are government-secured loans, that is, the government has promised the banks that they would protect their investment for lending the government-sponsored loan in the first instance, the financial institutions refuse to reveal the true accounting to prove that there is no outstanding balance with reference to any of the associated presumed mortgages. 47. Again, the intentions of the United States Congress and General Assembly was that every mortgage in America would be construed as a government obligations carrying with it the full faith and credit of the nation. 48. Since there is a representation of a mortgage on all the homes and all of the people in the United States of America, and since these mortgages represent a government obligations, every so-called foreclosure against any American citizen is deemed to be unconstitutional and against the law without specific authorization and authority from the United States to act in instead. And no privately held, privately run an organization can act on behalf of the sovereign, because the sovereign must only represent the public interest and never private interests with respect the United States of America and the government represented thereby. Memorandum of Law. Since the only law that is applicable in a common...
Ladies and gentlemen, this is where I think this is genius. This particular habeas corpus. My memorandum of law is the entire Credit River case where the judge gave his memorandum along with the verdict by the jury. Remember, it was the jury, when the jury read its verdict, that made this law nationwide precedent. Why was it a precedent nationwide? Because common law, you'll be able to hear what the judge said regarding the authority and regarding the capacity that he was sitting in. He was not sitting as a statutory judge when he did this. Again, he knew what he was talking about. Notice how he talks about jurisdiction. Notice how he talks about that the state law does not apply, that this was all federal, and that this was completely in line with the Constitution. Okay? So we're going to let that play. This section right here is what I wrote, but after that is the actual case, so I'll let you read it. I'll let you hear it.
Law case is the common law. I hereby have my own volition incorporate the following common law into the body of this presentment, and state clearly, professionally, and succinctly, that IT has stood for 50 years, has never been overturned, and is consistent with the principles and rules of common law, the Northwest Ordinance, which, as you can see, the court said IT relied upon, which means the Northwest Ordinance was still in effect and in full force in 1967 AD, which means as applicable here, at this stage, at this date. The Mahoney Credit River Decision RA. First National Bank of Montgomery vs. Jerome Daly. In the Justice Court, State of Minnesota, County of Scott, Township of Credit River, Justice Martin v. Mahoney. First National Bank of Montgomery. Plaintiff vs. Jerome Daly. Defendant. Judgment and Decree. The above entitled action came on before the court and a jury of 12 on December 7, 1968 at 10 a.m. Plaintiff appeared by its president Lawrence V. Morgan and was represented by its counsel, R. Melby. Defendant appeared on his own behalf. A jury of talesmen were called, impaneled, and sworn to try the issues in the case. Lawrence V. Morgan was the only witness called for plaintiff, and defendant testified as the only witness in his own behalf. Plaintiff brought this as a common law action for the recovery of the possession of Lot 19, Fairview Beach, Scott County, Minnesota. Plaintiff claimed title to the real property in question by foreclosure of a note and mortgage deed dated May 8, 1964, which plaintiff claimed was in default at the time foreclosure proceedings were started. Defendant appeared and answered that the plaintiff created the money and credit upon its own books by bookkeeping entry as the consideration for the note and mortgage of May 8, 1964, and alleged failure of the consideration for the mortgage deed, and alleged that the sheriff's sale passed no title to plaintiff. The issues tried to the jury were whether there was a lawful consideration and whether defendant had waived his rights to complain about the consideration, having paid on the note for almost 3 years. Mr. Morgan admitted that all of the money or credit which was used as a consideration was created upon their books, that this was standard banking practice exercised by their bank in combination with the Federal Reserve Bank of Minneapolis, another private bank, further that he knew of no United States statute or law that gave the plaintiff the authority to do this. Plaintiff further claimed that defendant, by using the ledger book, created credit, and by paying on the note and mortgage waived any right to complain about the consideration, and that the defendant was stopped from doing so. At 12:15 on December 7, 1968, the jury returned a unanimous verdict for the defendant. Now therefore, by virtue of the authority vested in me pursuant to the Declaration of Independence, the Northwest Ordinance of 1787, the Constitution of United States, and the Constitution and the laws of the State of Minnesota not inconsistent therewith, it is hereby ordered, adjudged, and decreed. 1. That the plaintiff is not entitled to recover the possession of Lot 19, Fairview Beach, Scott County, Minnesota, according to the plat thereof on file in the Register of Deeds office. 2. That because of failure of a lawful consideration, the note and mortgage dated May 8, 1964 are null and void. 3. That the sheriff's sale of the above described premises held on June 26, 1967 is null and void, of no effect. 4. That the plaintiff has no right, title, or interest in said premises or lien thereon as is above described. 5. That any provision in the Minnesota Constitution and any Minnesota statute binding the jurisdiction of this court is repugnant to the Constitution of the United States and to the Bill of Rights of the Minnesota Constitution and is null and void, and that this court has jurisdiction to render complete justice in this cause.
Hold on. Let me let y'all see what the judge did. After the jury came back with its verdict under common law, this judge knew exactly what he was doing, having this case under common law. He said that any provision under the Minnesota Constitution, now he makes it quite clear that even if there was a provision under the Minnesota Constitution or the Minnesota statutes binding the jurisdiction of this court, it is repugnant of the Constitution of the United States. Why? And the Bill of Rights of the Minnesota Constitution. Why? Because the Bill of Rights of the Minnesota Constitution has to be completely in line with the United States Constitution's Bill of Rights. That is mandated in the Northwest Ordinance, that all of their constitutions have to accept the Bill of Rights. That's why you see the Bill of Rights for the United States is completely the Northwest Ordinance. Everything in the Northwest Ordinance regarding those secured rights, those inalienable rights, are in each constitution. But he says is null and void, and that the court has jurisdiction to render complete justice in this case. Because remember, the courts are there to administer justice, and that's what he's saying he did. Now let's let him continue.
The following memorandum and any supplementary memorandum made and filed by this court in support of this judgment is hereby made a part hereof by reference. By the court. Dated December 9, 1968. Justice Martin v. Mahoney, Credit River Township, Scott County, Minnesota. Memorandum. The issues in this case were simple. There was no material dispute of the facts for the jury to resolve. Plaintiff admitted that it, in combination with the Federal Reserve Bank of Minneapolis, which are for all practical purposes, because of their interlocking activity and practices, and both being banking institutions incorporated under the laws of the United States, are in the law to be treated as one and the same bank, did create the entire $14,000 in money or credit upon its own books by bookkeeping entry. That this was the consideration used to support the note dated May 8, 1964 and the mortgage of the same date. The money and credit first came into existence when they created it. Mr. Morgan admitted that no United States law statute existed which gave him the right to do this. A lawful consideration must exist and be tendered to support the note. C. N. Schuser-Busch Brewing Company v. Emma Mason, 44 Minnesota 318,
You want to use this case too?
46 NW 558. The jury found that there was no consideration, and I agree. Only God can create something of value out of nothing. Even if defendant could be charged with waiver or estoppel as a matter of law, this is no defense to the plaintiff. The law leaves wrongdoers where it finds them. See sections 50, 51, and 52 of M. Jur. Second Actions on page 584. No action will lie to recover on a claim based upon, or in any manner depending upon, a fraudulent, illegal, or immoral transaction or contract to which plaintiff was a party. Plaintiff's act of creating credit is not authorized by the Constitution and laws of the United States, is unconstitutional and void, and is not a lawful consideration in the eyes of the law to support anything or upon which any lawful right can be built. Nothing in the Constitution of the United States limits the jurisdiction of this court, which is one of original jurisdiction with right of trial by jury guaranteed. This is a common law action. Minnesota cannot limit or impair the power of this court to render complete...
Hold on. Let me let y'all see, because he's giving fact. He is stating facts. He's coming to factual conclusions. That's why you hear the term facts and conclusions of law. Nothing in the Constitution of the United States limits the jurisdiction of this court. Why? Because he had original jurisdiction under common law. Watch. Which is one of original jurisdiction with right of trial by jury guaranteed. As long as there's $20 in value. So what you do is, if you're going to do a habeas corpus such as the one that I'm doing, you have to say that you were defrauded or you were injured to the sum of, and give them a value. Even if you're doing habeas corpus for incarceration of someone or for probation, put a value on it. Say that I have lost this amount since the beginning of this incident, and I am continuing to suffer loss to the tune of such and such per day. Keep it reasonable, because they'll question you on it. All right. It says any provision of the Constitution and laws of Minnesota which attempt to do so. What would they attempt to do? Well, Minnesota cannot limit or impair the power of the court to render complete justice between the parties. That's right, they can't, because the courts are there to administer justice. And one party who is in the wrong cannot prevail in a case where the other party is not in the wrong. Daley only brought one issue, that he didn't owe the banks any money because they had never lent him any money. Now, we're going to talk about that part in a second. Let's let it continue. But any provision in the Constitution or laws of Minnesota that attempt to do so is repugnant to the Constitution of the United States and is void. Any law that is contrary to the United States Constitution, and remember, they say the United States Constitution is the supreme law of the land. No, the United States Constitution is prima facie evidence of the supreme law of the land. What is the supreme law of the land? It is the Northwest Ordinance which was founded on common law. So common law is supreme law of the land. When you see the words original jurisdiction, that means common law. So the first question people should be asking the court, is this a court of original jurisdiction? That's your first question. Is this a court of original jurisdiction? If it is not, then I don't want to be here and I don't need to be here. Okay? If they don't answer the question, challenge jurisdiction immediately. Original jurisdiction is common law, people. That is what this judge is trying to let you know. That was the original jurisdiction for the United States. It was common law. That's why you hear the term original jurisdiction. That's why it's a legal phrase. It's not two separate words. All right, let me continue. No question as to the jurisdiction of this court was raised by either party at trial. What he's saying is both parties accepted the jurisdiction of the court, accepted the proceedings. They participated willingly. Pay attention. Both parties were given complete liberty to submit any and all facts to the jury, at least so far as they saw fit. He didn't restrict them as to the evidence that they could put forth before the jury, is what he's saying. He let the jury be the judge of the case. So let's continue.
Justice between the parties. Any provisions in the Constitution and laws of Minnesota which attempt to do so is repugnant to the Constitution of the United States and void. No question as to the jurisdiction of this court was raised by either party at the trial. Both parties were given complete liberty to submit any and all facts to the jury, at least in so far as they saw fit.
Oh, come on. She's having a bad day.
No complaint was made by plaintiff that plaintiff did not receive a fair trial. From the admissions made by Mr. Morgan, the path of duty was direct and clear for the jury. Their verdict could not reasonably been otherwise. Justice was rendered completely and without denial, promptly and without delay, freely and without...
Ladies and gentlemen, I like this judge. Let me show you how he covered his anus. He also covered the jury. No complaint was made by the plaintiff that the plaintiff did not receive a fair trial. The plaintiff did not object to the trial. From the admissions made by Mr. Morgan, the bank manager, the path of duty was direct and clear for the jury. The verdict could not reasonably have been otherwise. See, the jury was reasonable in their determination because it was based on the facts presented to them, is what he said. Remember, a jury must come to a conclusion and decision, and any other reasonable jury would have come to the same conclusion based on the facts of the case. That's what he's doing. He's covering that so there could be no appeal because they could not do it. Pay attention. When you go back and you look at the history of this case, you'll see that the Supreme Court claimed that the case was rendered void, but they didn't do it in this case. They did it in another case. You can't do that. This is a jury trial. They would have to actually come in this case and render it void, but they couldn't. Do you know why? Because no one challenged the case. None of the parties challenged the case. The Morgan did file an appeal. He was given 7 days. He filed an appeal, but he used legal tender to pay the deposit. He gave a $1 bill and another $1 bill, so he gave two $1 bills. None of the bills he used was backed by any substance. The court refused to accept them because, as the Treasury has said, legal tender has no value. What is legal tender? It is the coupons used between the banks to trade between each other. It is not meant for us. It is not money. It was never supposed to be money. Go look at the notes. Go look at 12 U.S.C. 411. It is to be used by the banks and for no other purpose. The banks can't lend that stuff to you, people. It's not theirs to lend. It is only theirs to use between each other. We're not supposed to be using legal tender. But let me let him finish so y'all can see that this judge was not no newcomer. He knew what he was doing, and it cost him his life.
Purchase, conformable to the laws in this court of December 7, 1968. By the court. December 9, 1968. Justice Martin V. Mahoney. Credit River Township, Scott County, Minnesota. Note: it has never been doubted that a note given on a consideration which is prohibited by law is void. It has been determined, independent of acts of Congress, that sailing under the license of an enemy is illegal. The emission of bills of credit upon the books of these private corporations for the purpose of private gain is not warranted by the Constitution of the United States and...
Do you guys understand what he just said? Because I didn't even pay attention to it at first. I understood it, but I didn't pay attention to it. Notice this. Note. This is coming from someone else. This is Jerome Daly speaking. It has never been doubted that a note given on a consideration which is prohibited by law is void. Ladies and gentlemen, what is he talking about? It has been determined independent of acts of Congress, so it doesn't matter if Congress made a statute, that selling under the license of an enemy is illegal. Well, what the banks did by creating their own money without having the authority, something that Congress only has the authority, they made themselves enemies of the United States. Okay, so their actions were construed as illegal. That's what he's saying. The emissions of bills of credit upon their books of these private corporations for the purpose of private gain is not warranted by the Constitution of the United States and is not lawful. And then he gives you the report that you can go and take a look at. Okay, this court can tread only in the path marked out by duty. And then he gives the Minnesota code so that they could focus on. Why? Because the court can only act within the jurisdiction prescribed for it. Too many case laws that says that. Without jurisdiction, the court is prohibited, cannot act, cannot move one step forward. That's what he's saying. So he's saying the judge made a legal determination and a lawful decision. The jury came to a lawful conclusion. All right, let's let it continue.
Is unlawful. See Craig v. Mo4 Peters Reports 912. This court can tread only that path which is marked out by duty. MVM. Jerome Daly had his own information to reveal about this case, which establishes that between his own revealed information and the fact that Justice Martin V. Mahoney was murdered 6 months after he entered the Credit River decision on the books of the court, why the case was never legally overturned, nor can it be.
Exactly.
Jerome Daly's own entry. Regarding Justice Mahoney's memorandum.
Oh, I'm sorry, and that wasn't Jerome Daly
Forward,
who wrote that.
The above judgment was entered by the court on December 9, 1968.
That was the other individual who was put there by the Supreme Court.
Nothing in the law gave the banks the right to create money on their books. The bank filed a notice of appeal within 10 days. The appeal statutes must be strictly followed, otherwise the district court does not acquire jurisdiction upon appeal. To effect the appeal, the bank had to deposit $2 with the clerk within 10 days for payment to the justice when he made his return to the district court. The bank deposited two $1 Federal Reserve notes. The justice refused the notes and refused to allow the appeal upon the grounds that the notes were unlawful and void for any purpose. The decision is addressed to the legality of these notes and the Federal Reserve System. The cases of Edwards v. Kearnsey and Craig v. S. Missouri set out in the decision should be studied very carefully as they bear on the inviolability of contracts. 49. What we have here is the court documenting that common law is universal for the United States of America, and that the unanimous decision made in court was in conjunction with the right to a trial by jury. See the 7th article of the original Constitution and the Northwest Ordinance, which in 1968 the court held was still Indiana force and applicable. 50. The court also documented the fact that the banks have a practice of creating what is deemed or termed money, which is in fact not defined in the Constitution, not authorized by Congress, who has the power to regulate money, which makes it a violation of the Gold Abrogation Act of June 5, 1933, and obstructs the power of the Congress to regulate the currencies of the United States, and has been held by the United States Congress as being against public policy. 51. The administrative courts have been condoning this unconstitutional and unlawful practice by these financial institutions during this current national emergency, an emergency that was so serious that it has lasted for greater than 85 years. 52. It is for this exact reason that monies are only authorized to be printed by the United States Department of Treasury. This is specifically spelled out in the Economic Banking Emergency Relief Act of March 9, 1933, an act that lays out stiff penalties for anyone who violates this act. The facts indicate that the banks and their practices are in direct violation of public policy, the power of the Congress to regulate the currencies in America, and the United States of America Constitution, which is founded upon the Northwest Ordinance. 53. This practice is holding us hostage, in bondage, in involuntary servitude, for at mealtime did the financial institution indicate to us that they were lending us something that had no value, that was not regulated by Congress, and was not authorized under the financial laws of the United States of America. 54. As at current there is a claim that somehow the banks lent $s, when in fact this would be fraud, this would be counterfeit currency. Which would mean that the financial crisis of 2008 and of the previous decades were nonetheless a fraudulent claim by the financial institutions and their main member bank, the Federal Reserve, and all of the cases whereby such unlawful and unvalued consideration has been introduced, no matter the form and no matter the party, such constitute an attempt to defraud the American public, the American government, and the American judicial branch of government, equating to fraud upon the court. 55. Again, this practice has been officially declared to be unconstitutional under common law, and if it's unconstitutional under common law, it's unconstitutional under administrative / statutory / regulatory / ordinance / and or other prescription of law. 56. The United States of America does not recognize the authority of any organization, especially ones that are privately held and ran to create currency. 56. For if a privately held and ran organization had the right to create currency, it would devalue the entire system, including the so-called world default currency, the American dollar. 57. Since the financial industry, and this would include the Federal Reserve banks and their member banks, does not have the authority, the delegation of power, and order capacity to redefine what money is, they do not have the authority to invent it either. 58. Because we are still in the current national serious emergency economic banking situation, this would mean that each one of the American citizens, the United States citizens, the Native Americans, the Mexican Americans, and any other demographic within the borders of the United States, their possessions, territories, and or military installations fall under the protection of that emergency declared by the General Assembly of the United States of America Congress. Now, although I seek personal protection against this act of Congress because they admitted that they had acted without constitutional authority, which makes the act itself unconstitutional as declared by Congress in the notes associated with the Act of March 9, 1933, that a part of the Federal Registry which makes it a fact and law. There is still no authority for the Federal Reserve and / or their member banks to create money, currency, value that would be binding on the American public. As said before, so we / I say again, it is against public policy, which means it is against the public interest, which means it is unconstitutional. 59. As a direct result of these unconstitutional acts, my liberties are being constrained and restrained myself. I have attained the age of majority, but yet there is no public policy in place for documenting this that is available to the public upon request, in violation of due process and the right to access government. 60. Obtaining and attaining the age of majority is not a privilege, it is a natural right, a common law right. Here in America and throughout the world, the administrative agencies have created a plethora of laws, procedures, policies that interfere with this right, a right recognized at common law. 61. I have attained the age of majority, I disaffirm any and all contracts made during infancy, I have resigned as registered agent for the state agency, I am completely competent, rational, and capable of handling all of my affairs without the assistance of government. I have the right to my securities held in trust by the government as a result of the March 9, 1933 Act and other previous and / or subsequent acts of Congress. 62. I say that government had an obligation to provide a clear and precise explanation and or remedy for any rule, regulation, law, policy, procedure that affected the lives and rights, common law and / or otherwise, of American citizens. This was to have been in the common language of the people, and if the individual spoke a different language, a translator is the acceptable form of communication for such a situation. Yet this has not been done, the policies, procedures, processes have not been spelled out in clear and understandable language as any normal man or woman could reasonably understand, which makes it unconstitutional. 63. I have the right to be at liberty, the right to my property, the right to contract, the right to be recognized as having obtained the age of majority, the right to be competent, and any restraint or constraint on these rights that are all construed as liberties is cognizable under the right to petition for habeas corpus via writ under common law, and I henceforth care to forthwith make such a petition and must insist on expediency because of the damage being caused by the delay in Lack of access to government. The aforementioned is true as well as accurate and is attested to as well as declared as well as certified as well as stipulated on this June 1st, 2018 at 1:04 p.m., as such so help me Jehovah the only true Lord and Sovereign, God. By Citizen EEN underscore 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 underscore.
As a matter of fact, I can stop her because it's finished. All right, ladies and gentlemen, the whole idea of this was for you to get a better understanding. You see, when you look at habeas corpus and why habeas corpus is put together in the first place. Now, mind you, we are doing this. Oh, I'm sorry. There's something else I did not include. And so that's number 13 that I was supposed to be including. Remember I said I left that open because I was going to come back to that. I just needed to get there. So give us a second. There's a number 13 I highlighted. And the areas that I highlighted is where I was supposed to be introducing information. Such as you saw me highlight the $sign. That's where I'm supposed to be explaining that by the banks utilizing that $sign and saying that that's what they lent. They are playing a fraud upon the people and the American government because that sign is universally recognized as the symbol for the American dollar. Universally recognized. I'm looking for where I did that, where I put that thing, that little number, but it's going to be further down by itself. And I don't think I highlighted that one, but I don't know. I think I left it. So, oh well, I'll get to it at another time. It's because of the format of this particular document. You see, you notice how I changed the format of my pleadings by putting it on this type of a document? Well, it's trying to read every page, so that's why it's going through this. No, that's not it either. I think that's where it was supposed to be, number 13. That's why I remember number 13. So I think, yes, that's where it is. So it's going to be number 14 now. All right. So now it's going to be number 14, and this is going to talk about, no, I think I did number 13. I did number 13 correctly. I did fill in 13. It's the other one I need to do, so now I need to undo these. Uh-oh, don't need to undo that. Let's put that back, that henceforth thing. All right, talking about the court having original jurisdiction, you must put in there the jurisdiction of the court, what you're looking for. But you know what? Sorry, I do have to change that. Okay, what we're doing is, give me a second. I'm going to speak it into the computer and then I'll bring. Okay, ladies and gentlemen, what most of you don't know is that the courts must construe a pro se litigant's pleadings liberally. The courts are never to construe your documents. Your documents mean what they say and they say what they mean. You're not meaning something else. So what the court believes the person is trying to say is this. Don't give them that opportunity. So pay attention. All of the words, the context, the intent within this presentment are to be construed under the general common law in conjunction with the rules of common law, which shall encompass the Northwest Ordinance and the Bill of Rights of the United States of America Constitution. No other construction is warranted, is necessary, and or is acceptable in any circumstances. We get rid of all of that, them construing it however they want. You see, that's why they were trying to tell everybody what Jerome Daley was trying to say and trying to do. You don't get to do that. You don't get to tell anybody what I'm trying to do if the evidence is not there. That's why they say he admitted it on the record. That he admitted this, he admitted that, because they needed intent. It was only after they got the intent on the record that they go and kill the judge. Pay attention, people. I didn't even know about this case. I read it before, but I did not know that the Supreme Court had come in. I didn't find out about the Supreme Court until yesterday, that they had made a decision. But Jerome Daley agrees with me that they didn't follow procedure. So their decision to quote unquote claim that this case was void is void, because the law says there's a proper procedure for overturning a case. You can't overturn this case in another case. Okay, you can't. For instance, if I go to court and I win tomorrow, you can't bring another lawsuit in another month in another proceeding dealing with different issues and then overturn my case. The new case would set the precedent. The old case would remain the way it was. The new case would set what's called, what they refer to as a precedent. Okay? A new understanding. But you can't come in and take my case and make my case invalid. You don't have that authority. And that's what they did with the Jerome Daly situation. That's why he said that they couldn't lawfully overturn the case. And he knew they couldn't. They're restricted by the Constitution. If they had allowed Justice Mahoney to live, you know he would have been appealing it federally and to the federal court. They never would have let this go. All right, ladies and gentlemen, this is just an idea for some of you who are running out of options. Oh, by the way, guess how much it costs to file a habeas corpus in federal court when one is being restrained of their liberty? $5. That's right, $5. And we're asking for a jury trial because it's a civil proceeding. Okay? So I just wanted to bring this to you all's attention. This is what we're working on. We have some other information. Hey, by the way, ladies and gentlemen, the CUSID numbers on the video, I don't have an account with Fidelity, so I couldn't show you how to get access to all the other CUSID numbers. As soon as I work it out with Fidelity, because ever since I gave them that instrument for $600,000 that they told me that they would have deposited into the account had the account not closed, if that was the case, you know, if I hadn't done that with the hour style money order, then I would have access to the account, even though the account closed in 2012. So I'm trying to open up a different account now. We will talk, ladies and gentlemen. Have a good day, have a good life, have a good night, and hey, whatever you do, make it good. I hope this information proved helpful to some of you. Goodbye.